So welcome back again. I will wait for one more minute. Unfortunately, we have no news from Michelle, so we don't know whether she's able to come back or not. Okay, so I would suggest to start. Thank you again for all of you who are back, in particular to our speakers, Frank and Martin, for being back on time. And let's hope that Michelle is able to rejoin whenever she has solved this power outage issue. I would like to start by asking a question on my own, if I may, and then suggest that we go through the questions that were asked. The question that I have is a very fundamental one, and it's a question that I would really appreciate to receive answers from both of you, which is very simple. It's the following one. Since the beginning of data protection law, so somewhere since 1970, I think, and also then after the decision of the German Constitutional Court on informational self-determination in 1983, it has been absolutely set in stone that it makes sense to draw this very basic distinction between personal and non-personal data, and that data protection law is only about personal data and all the rest is somewhere else in the law, right? So in my view, I always see myself in a very weird situation, because whenever you have a data protection problem in front of you, the very first question is the whole field of law applicable at all? And then you end up in this debate that we are in at the moment. And the question that I have to both of you from a technical and from a legal perspective is to imagine that that there is a new world appearing in front of us, and the question that we would need to decide would be whether we still should draw this distinction at all, or whether it would not be a more appropriate way to say we don't mind whether it's personal or non-personal, because there are certain risks coming with data, and let's think more about the risks than about this classification. What would you answer?
So who shall start?
Maybe
do you want?
Later.
Okay, then I will start. So I wrote, as I have already mentioned, I wrote my dissertation on the subject, what is personal data? And I think, if I remember, that are 475 pages or 57, I don't know. But at the end, I really had the feeling, okay, it's so much more complicated. And my result was, it's really difficult to say where is the strict border of what is personal data and what is no personal data. But I think it's not necessary, because in law, we often don't have facts. We have opinions, and we have opinions, and so I think we could live with it. I have given this concept of personal data a chance, and I think it's necessary to think about it. And to find criterions, for example, for identification. What is a natural person? So the discussion in the literature and at the laws for the question, what is a natural person? What is a living human? Is just, okay, is he living, or is he already, has he already died, or has he been born? And is it a legal person or a natural person? I think there are a lot of more interesting questions which are necessary. So is a natural person a body of a person, the thoughts of the person, the acting of a person? Is there what is the identification? Is there a virtual identity? So if I have a separate virtual identity of myself, for example, a Bitcoin account, and I'm the only one who knows that this account is my account, it's totally separated from me as what I think I am as a living human. But it's nevertheless it's my account, and I'm dealing with this account, and we have to answer this question. Okay, is this virtual identity? Is there a virtual identity, and is it a natural person? Just as an example. So I think we have to have more conferences like this, more articles like Frank and Michelle have written, and we have to think about this question, because there's a strong weakness of privacy protection and postal secrecy and so on.
Mm-hmm. Right.
So I agree that the idea is basically quite appealing, not to think from this binary decision whether something is personal data or not, and that also goes well in line with the fundamental considerations from this 1971 report from Steinmüller and colleagues, where basically what the focus was on was always this: what is the impact that a human being can or might be exposed to, and so on. So in that regard, I totally agree and find it appealing, especially when we think about situations where which are coming up increasingly today, and which could possibly not have been foreseen in the beginning of data protection law, where we might discriminate individual human beings without actually having some data that is explicitly linked to this human being, but rather a or a profile that sorts this human being into a certain box or so, and that was the original intention, to prevent such such discriminations and so on. And insofar, I agree that the idea of just thinking from the point of risks and in a more relative way, like this one seems to be or is becoming more critical and so on, that is a viable goal, a goal that is worth to think about. I do, however, have my doubts regarding operationalizing it. So from my perspective, when I'm discussing or teaching such interdisciplinary stuff to my computer science students, it helps a lot to just answer or ask this question: is that personal data or not? And it's also very helpful in matters of legal operationalization. I think it would be overly complicated at the moment, at least, if we not had this anchor. So basically, it would be nice, but probably hard to put in practice and action.
But with all due respect, this is also true for the existing situation, right? I mean, this is one of the things that we learned, I think, so far, that also the existing framework is hard to be put in action. Yeah. Okay.
And Nikolaus,
yeah.
if I may,
Yeah.
I have a question in this context. We are always talking about the protection of natural persons at the processing of personal data. Another question that I have is why the processing of personal data is regulated so strictly, and on the other hand, the processing of other data and the regulation of knowledge is so liberate, so free. So I have explanations for that, because we have a freedom of information, we have you can have your opinion, we have a freedom of science, yeah, and it's for us it's quite obviously that to gain knowledge, common knowledge, or to have developments, it's not very much regulated. But if it is knowledge about a singular person, about the individual, suddenly we have this regulation on the processing of personal data. And an example for that, why I asked this question, is, for example, the example that I give with Friedrichshain-Kreuzberg. Now, the information that we have 7-day incidence of, I don't know, at the moment of 100, we could guess. It's also information what can discriminate a single person. So, for example, I could not go on holidays where I want to go. Yeah? It's not just information about me as a unique natural person, but it's information about a group. And there's no regulation. It's not my opinion that we need this regulation or that we need a strict regulation of processing all information and knowledge. But the question is also why the processing of personal data is regulated so strictly and so formal. And if you read the GDPR, I don't know how many pages, it depends on the document that you have, 100 pages. It's crazy. So I think it's not just a question of the scope, there's also a question of the regulation behind. Yeah? Why there is a so big difference between the two situations that we have personal data with a very broadly interpretation of personal data, and if we have the processing of no personal data. Of course, the misuse according to one single person and the discrimination can be much higher, and it's felt not really good if someone as a single person is discriminated, but I think it's also an important and interesting question.
Yeah, that was more a statement than a question, Martin, but if I may reply, I think you are completely right that it's really astonishing from an objective point of view that we have this dilemma here, that there's all kind of rules when it comes to personal data and so little when it comes to non-personal. But if I may add something about the regulation issue on non-personal data, there is a huge debate on this. And I mean, the buzzwords used there are property law, in how far should there be some kind of property rights to non-personal data, and or digital sovereignty. That is probably the term that is used by many of the politicians at the moment. And the mainstream answer to this would be there should not be anything like property or similar to property law regulation here, because it would hinder innovation. So the typical argument for the freedom argument is the less regulation you have, the more plausible it is that something might be, some innovative development might come out of this. Right? And when it comes to the strict rules on data protection, I think, this is a historical coincidence in a way that, in particular, the decision of the Constitutional Court in 1983 came up so early with this in Germany.
Mm-hmm. But property law also has a scope. Yeah? And
of course. Yeah, and all kinds of rights and obligations coming with it. Eigentum verpflichtet, right? So
yeah, of course.
That would be a lot of stuff for next year's conference, I think, right? So, but perhaps we come back to the questions, and I would suggest that to go through them in chronological order, because then we are sure that we don't miss any of them. And I assume that all panelists and also the audience are able to see the questions in the Q&A sections. Let's start with this one. The first one coming from Preet. Frank, is probably going to you, and it's a very technical one. Would you like to reply to that one?
So which question exactly are you?
It's hello, if the encoder gives always the same output for the same input. Do you see this in the Q&A section?
No, I don't see that.
You don't have a Q&A section?
I have a Q&A section which currently contains 3 open questions.
Okay, so that's strange. I have 7 here.
I remember I had a Q&A per video, and that emptied as soon as
okay.
So
then sorry. So then let me read this for you. Hello, if the encoder gives always the same output for the same input, then there shall be complications when I have 10 plus James Millers in the same data set. In case, let's say, I know that Jane Miller is in the list, there are many online SHA-3 256 calculators to calculate this matching value. True? Question mark.
Yes, absolutely true. I probably did not stress too much that my example was kind of simplified. So usually you would have a unique Jane Miller. In that case, you might I might have replaced it by a unique citizen ID or whatever, with all the hassles that come with that. So yes, it produces always the same output for one Jane Miller, and it presumes that you have a unique input and not multiple persons with the same identifier. So that was just a simplification.
Mm-hmm.
And that's so usually this approach. So many things come clear when you think from the perspective of how do we store passwords. There you have a unique user account, and that user account is then bound to a certain password or so. So in that case, yes.
Mm-hmm. Mm-hmm.
Probably just an issue of oversimplification on my side.
Okay, thank you. So next question for the panel. Did I get something wrong? As far as I know about traditional pseudonymization, it is often sufficient to be able to produce or watch one event with a person to get one person identified in the whole data set. No salting, just traditional. Or have additional knowledge about peaks or characteristics of the sensitive data where no access to the pseudonymization table is necessary for identifying a person, as far as I know. Is this not relevant for lawyers? Question mark.
It is. I think it was my fifth slide or so that I today only wanted to talk about ID-based and not about content-based stuff, mm-hmm. And only about hash. So there would be a completely additional story when you think about re-identifying people based on the content. I think at some point I said we could also think about mapping bank account transactions with buying transactions occurring at the same time with the same amount or so. That would be content-based re-identification and not identity-based re-identification. And that would be a completely new story. I had some, so initially I began and had some 20 additional slides on that or so. Mm-hmm. So yes, that's true, and that's something that would also have to be examined. But as said, you have to limit stuff.
Yeah, of course, yeah. So 2 questions to you now, Martin, I think. The first one is, are there instances where assumptions about natural persons are caught by the GDPR?
So assumptions, so information can be as assumption, as I mentioned, and an assumption always has a probability, and it's not in the GDPR because it's the wording of Article 4, Paragraph 1 is information relating to an identified or identifiable natural person. But if you interpret this criterion, then you, I would say, you also have to take into account probabilities and assumption. And of course, you have something like an assumption and a probability in recital 26.
Yes. Okay. And next question is about whether you could discuss your 7th example on your slides, which is the encrypted zero knowledge, only natural person has the key.
Yeah.
Does that amount to personal data in your opinion?
That is also a question if a decoding, so if there are, how strong the encryption is, of course. So if others would have means to hack this encryption, then of course it would be personal data. But if you have an encryption which is, if you do the math and if it is quite safe, and you can assume that no one else in the next 10, 100 years would not get access, I would say it's not information about an identified natural person, because then the identification is controlled by the natural person itself.
Mm-hmm.
And if this natural person do not give this information to other people, it's quite secure. So if only the natural person itself has access to the personal data, then it's not information relayed to identified natural person in the sense of Article 4, paragraph 1, in my opinion. Another example would be the blockchain account. Or we take the example Bitcoin account. If I would not say that I have an account, and if I would not give this information about this account to other persons, the number of this account, and I would control this information, then I would say it would not be personal data, because I, as a natural person, am the controller, and it's not. I cannot be the controller and the data subject at the same time.
Mm-hmm. Mm-hmm. Which is a very interesting question, by the way, whether data subjects can be at the same time controller of their own data.
So the third conference.
Yeah, that's already the third conference. Well, you were very short in your remark now that you can't be that at the same time. Would you like to put an additional minute into this in developing the argument? Why not?
Because of the aim and sense of data protection, there's no danger of misuse and discrimination. So if, of course, there could be a situation where I discriminate myself, so you could discuss it, but that should not be protected by data protection law. And if there is not this danger of discrimination and data power of other peoples, like the constitutional court says, we should not live in a world where other people, other bodies have information about my person, and that is restricting my freedom. I would say my knowledge about my own person could also restrict my freedom, but it's not falling under the sense and aim of data protection law.
Okay, Frank, then there's a question which goes, I think, a little bit into my direction from my question before. Somebody is asking for the panel, a controller as well as a processor must always meet security measures. Why should anonymization lead to more effort? What if there is no anonymization, then data protection must always be observed? Would that be so impractical? Isn't it almost more complicated to worry about whether a data set is anonymous every time? So it's quite the same argument that I made before, right? So the distinction is more complicated than simply following the rule. That's the question.
So in a way, yes. And so that one is the first one I can read. I think we have to strictly distinguish between security measures and data minimization measures. That's the first thing. So we have those principles, we have data minimization, we have security, we have purpose limitation and so on. And we have to distinguish between security measures and data minimization measures. So that's probably before the bracket. I agree with this argument as long as it is possible to do what you want to do with anonymized data. So in that case, there is the obligation to anonymize, to do data minimization as far as possible if you can. So anonymization is definitely a part of data minimization because it minimizes the amount of personal data. And therefore, you have to minimize and thus anonymize data as far as possible. However, there are situations where you cannot anonymize things. So think about a transaction table, a buying list or so. It does not make sense to have your customer purchases in an anonymized form that you cannot re-identify anymore. And a similar thing applies to those use cases where we want to put a claim on a blockchain or so. That does not make sense in total anonymity. So there are cases where non-anonymity is necessary in order to fulfill or to serve a certain goal or so. So that's something that, of course, my computer science student always think about, wow, let's just anonymize everything and throw away every data, and then we have solved all the data protection problems. But in fact, there are situations where you cannot implement a certain function without having some non-anonymous data. And only for those cases, we have to think about how far we might somehow depersonalize it, or if we put data somewhere in a depersonalized form that still allows to fulfill the original goal. If that answers the question, sure. We in an ideal world we would just aggregate always at least 100 persons or so, but there are cases where this is not feasible.
Yeah. Martin, would you like to add something to this?
No, thanks.
Thank you. Okay. So then Chiara is asking something about Apple and Tesla. Perhaps, Chiara, you could kindly clarify a little bit more the context of the question, because I don't fully understand that as it stands at the moment. I would, instead of this, now ask or read the agreement or the statement of Nadesha Pultova on agreeing or not agreeing on what Martin said before. So I read this. I strongly disagree with the last comment. The fact that an instance of processing lies outside of the scope of data protection law by virtue of the household exemption does not mean that the data is not personal. In one of its opinions, Article 29 Working Party explains that when an individual is a controller but falls outside of the GDPR due to the household exemption, the service provider is a processor and still, to a limited extent, bound by the data protection law. So when the controller is a data subject and the data is encrypted, it does not automatically mean it is not personal data.
So yeah, that I have another opinion, because it's a question of identification, and I would interpret identification like identification by others. And if there is no identification of the natural person possible, it is not personal data in my point of view, because of the purpose and aims of data protection, as I already have mentioned. And I think this household activities, we have to differentiate. So we have, this is important, yeah, but there are other situations where we have this household activities than just if someone have his own information or control his own information, because this household activities are all also existing. If my neighbor, for example, have a calendar and writes down my birthday, then he is controlling this data, then it is personal data because it's another natural person, but nevertheless it would not fall under the scope of the GDPR because it's a household activity. And my example is a special case of household activity. Perhaps you can see it as a special case of household activity. It's not just an household activity or private activity, it's an activity on my own, so that I, as a natural person, totally control the information about my person. And then I would say there's no need for data protection. But yeah, of course, you can dispute it.
Yeah, and I think Nadezhda will have the opportunity to debate that more in detail in her presentation. So we are going to listen to this a little bit later with even more interest now. And Martin, you will need to, if you still have the time, then you should reply then again on this perhaps after that presentation.
I will prepare myself.
Yeah. Okay, next thing, we have one that goes to the panel, and that was in the chat, and I would really like to ask both of you of this, and in particular probably you, Frank, because it also is about the joint paper. Somebody was asking or saying here, the argumentation for a risk-based approach seems to be more political than legal. How would you respond to such a statement? So is this, where is the distinction to be drawn between political assumptions about what should the world look like and the legal argument?
Yeah, it's a pity that Michelle is not here now, because it was basically so she has the answers in mind.
Okay.
Well, I wouldn't say it is legal. It is purely political. But as far as I remember, so what we observed was that even on the legal side, the arguments were not consistent regarding the absolute versus the relative approach. There is this wonderful example from the Article 29 party, which somewhat contradicts itself. But in the end, I wouldn't say it is just political. So in the sense of that doesn't make sense and we want something else, so therefore this and that, but rather, so I would have to look it up. But in the end, I'm quite confident we found enough indications in the legal documents and in the discussions preceding, for instance, the GDPR, that there is a risk-based mindset embodied in the legal givens. But in the end, Michelle would have been able to give a more precise answer.
Yeah, thank you. Thank you. Martin, I think you would agree, wouldn't you?
Yeah.
Yeah, that was short. So Chiara now has expanded the question. Thank you for this, Chiara. I try to find this here. Yeah, so she's asking the following. The network privacy expertise concluded on the 19th of October that Tesla cars are unlikely to be registered in the EU because of many privacy violations. The question then is, it seems that iPhone and Apple sufficiently apply to GDPR principles of data minimization and Tesla does not. And the question now is whether there are technical and legal differences between the two cases in regard to identification and minimization. Okay, I understand. Okay, so is there a difference, a legal/technical difference between identification, pseudonymization, anonymization techniques used in the case iPhone, Apple on the one hand and Tesla on the other hand? I don't know who wants to answer this.
I might jump in with an educated guess. So I did not explicitly examine what Tesla actually does, but I'm quite confident they are not caring a lot about. Whereas I know, so we have a similar distinction when we stay in the phone space between Apple and, say, Google, where you will typically recognize that Apple's virtual assistant Siri is worse at understanding what you want from the assistant than Google's virtual assistant is. And this is the case because Apple explicitly designed the whole thing so that they perform the largest part of the speech recognition on the phone and do not put or send all that data to a central server or so, which would make machine learning and natural language learning way easier and way better. But Apple explicitly decided not to do so. And this is, Apple is already sending TV ads on that, at least in Germany, just highlighting their well, that they are caring about privacy and data protection issues, and seeing that as a unique selling point, especially as opposed to other companies like Google or even Amazon with the Alexa leaks of things that have been said within the own living room or so. And at least as far as I got it from the media, Apple, Tesla also sends loads of data, especially camera stuff, looking outside of the car as well as what happens inside the car to some central service for optimizing things even more. So I'm quite sure Tesla is in need for some privacy engineers who actually have an idea what privacy by design is. So yeah, I would say yes.
Yeah, I would just like to add that I happened to be in Berlin about 2 weeks ago, and I saw a huge advertisement of Apple proactively arguing that they take privacy seriously, right? So it's privacy as a key selling argument is making a career, at least in Berlin, at least from Apple at the moment. Yeah.
Yeah. What Germany tried to ensure for decades.
Yeah. Yeah. Interesting in a way. Yeah. Yeah. Martin, would you like to add something to this?
So I would assume that in both cases we have identifiers, and theoretically there would be identification possible of natural person, and then it's a question, what are they doing, how they are processing the data in detail, and I do not have the background, so I cannot say a lot to it.
Yeah. Okay, let me perhaps continue with one question that I have to you, Martin, because when I heard well, actually, there's a comment. I will read the comment and then I will ask my question. The comment is, Apple might try and take confidentiality seriously, but that's a far cry from privacy or data protection. I've written on this in IDPL, so the author of this question. So it's more a comment than a question then. And we will again listen to you later, Michael, on this in your own presentation. Very much looking forward to this. So Martin, you really need to stay here, and Frank, you really need to stay here because there will be plenty of comments on your presentations, which is the optimum in a way that that can happen in a conference that other people are referring to what you're saying. The question to you, Martin, is when I saw all the cases that you were referring to, one of the things that were interesting to me was that you did not really actively, at least in my reading, take care of or quote or cite the existing jurisdiction in the field, right? So the question I have to you now is, how could it be, or how can it be that in such a fundamental question, which is are we in this field of the law or are we not? The role of jurisdiction after 50 years of existence of this question is still so relatively low. I mean, both in your presentations and also in all three presentations, actually, I think the only decision that was mentioned once by Michelle was the Breyer decision, and all the rest is still completely out in the blue. So how can that be?
If I may correct you, I had a slide when it was what is identification, and I had two citations from the ECG, at least on the Lindquist case. Yeah, someone is identified if he is recognized. Yeah? I think that's not very helpful. And another was on another case. And one reason is that I talked about what is identification, and I haven't talked about what is identifiability, because according to this question, what is identifiability, we have a lot of jurisdiction. The ECG, the case what Michelle was citing, was a Breyer case that we all know, and in Germany we have cases if the car plate is personal data, for example, or we also have a case from the court in Bayreuth, the administration court, on hashing on customer audience, which is used and offered by Facebook with their customers. And there we have a hashing of this information because Facebook is just interested in bringing the advertising at the right pages, at the customers of a company. And there, for example, we have a court decision which says that there is personal data. But we, in these court decisions, we do not find a lot of explanations or definitions of what identification really is. Mm-hmm. And that is one answer. I think in data protection law, we have another problem in Germany. We have, I think, a lot of disputes are already solved or discussed with the authority agencies, data authority agencies, and they do not come to the courts. So I think that is a phenomenon. That is a theory. I haven't checked it, but we have in every Bundesland we have authority, data protection authority, and I think often the disputes stop there and do not go to the courts. And perhaps that was also a reason why Michelle also cited a lot of or dealt on the opinions of this data protection authorities. This could be two answers to that question.
Mm-hmm.
I might add up on that. I also think that many things are handled and decided based on opinions, for instance, and then there is a problem that those opinions are sometimes also misguided. So so we have several occasions where what comes up, and everybody knows how those opinions from the former Article 29 group actually are created. It's not necessarily the case that these are absolutely well informed, and I think in many cases everything refers to those opinions, whereas we do not have, at least on a European level, in English language, the whole the large body of commentaries and so on, where discussions are laid out with all their pros and cons and so on, and that's something we're lacking. Probably all the German legal scholars which made a lot, so which have a very clear view and a very intensive discussion. Part of that should just be published in English, and that would probably already help.
Mm-hmm. Mm-hmm. But may I ask another question to you, Frank, in particular now? I mean, one of the issues that I see in many of the papers is not only that there are no decisions about them, that's what Martin mentioned, but it's also that not all of them are properly technically oriented, right? So there is a lot of, technical fuzziness when lawyers start to speculate about these things. And the question I have to you now is, why are you doing this then? I mean, from the problem that I see here, it goes a little bit into the how academic careers and how reputation building and so on works in European universities, and taking the time and the expertise and the knowledge that you need to show up at a conference as this one here is high. So you need a lot of effort, and the individual outcome at the end, in many cases, is low, because in your own discipline, this is just another weird, field like many others. So isn't this a problem that needs to be changed? And if so, how could we?
So I totally agree. The KPIs that I am benchmarked against absolutely disencourage something like that. And we have a completely different citation culture, and that already that citation culture makes such transdisciplinary things complicated, because the incentives are clearly speaking against investing time, against always translating between two different languages, which is that takes time. As you asked why I am doing it, it's just because it makes me crazy to see things that are technically not correct on the legal side.
Yeah.
But yes, I'm not sure. I have been thinking about the question how we could encourage and also, well, somehow benefit and realign the incentive systems that we see in academia, so that things like this happen more. I, to a certain extent, also said I'm doing it nonetheless, even though it does not benefit, and my time would be invested better somewhere else. If I just were looking at the KPIs. But yes, there is a need for realigning this, and I did not come up with a solution to that. That goes beyond hiring folks not only on the basis of your Google Scholar citations or so. That is a fundamental problem with every kind of inter and transdisciplinary research, but I think it is especially present when we're talking about bringing together computer science and the law. That's true.
Yeah. And you, Martin, you see the same phenomenon from the other perspective, right? I mean, it's also the same problem when you as a lawyer end up teaching and educating computer scientists about the legal parts, aren't you?
That's true. Yeah, and of course, I have a big lag in this discipline, so my knowledge in computer science is very fundamental. And therefore, I'm very happy to have colleagues like Frank. But in my opinion, I think that's why I make it. It's very interesting to look at the things in an interdisciplinary way. And I love to give lectures at the technical university, because then I'm not just the person who is teaching my students. The students also are teaching me, because they have the economical background or the technical background. And in my point of view, that makes my lectures and my discussion or the discussions with the students very lively, because we realize how important it is that not just one person is telling to others about his thoughts, that there's a discussion and that everyone can take part in it. And sometimes I'm the one who learns the most from a lecture that I'm giving at the technical university, because there are always some people who are experts, a technical expert on that, what I'm discussing with them, and I like it.
Yeah, I don't want to go too deep in here, but just one last remark on this. I think there is a fundamental issue here at stake, which is also that at the very end, it's always lawyers deciding the cases, right? And if there is no incentive in academia for people to help lawyers to understand things, then there is no incentive in the real world out there than in the case, right? And there is no incentive for the judge then at all either to dig too deep into this, right? And it's very easy for a lawyer then to stay with the simple words as they are in the law, and that makes it quite difficult for interdisciplinary work also in court cases. But that would be the fourth the fourth conference topic now, I assume. There are two more comments in the Q&A, and I will simply read them because I don't think that there is any need to comment on the comment, but let's see. The first one is, in cases of the US-based companies, it seems that they use data protection and privacy as means to achieve their economic goals in Europe. We don't really see this happening with EU-based companies. Probably true. And then one person referring to the privacy paradox as the explanation for many of the things that we are discussing here at the moment, which is probably also right. Thank you. We are right in time. I think we have all questions answered that are on my plate here at least, and hopefully also on yours. So let's finish this first session by thanking again most warmly all three speakers, of who only two could be here today now in the panel debate. Thank you to you in particular, Frank and Martin. please stay with us if you can. And to all the others, thank you for being with us. Enjoy your lunch, and please come back in an hour. So we will restart again at 2. This conference here will remain open, but everyone is invited to mute your microphone and to, if you have one that is working, and then to come back at 2. Enjoy your lunch. Thank you so much. Thank you. All the best.
Thank you. Enjoy.
Thank you.